Good morning, Ms. Smith.
Good morning.
Good morning, Ms. Wood.
Good morning, Judge. How are you?
And everyone else here. Will the state be recalling Ms. Lynch?
We will not.
Okay. Did you find Ms. Lynch?
Yes.
And did she say, I'd be happy to come back?
No.
Okay. All right. We'll get all this on the record when Ms. Rivers pops back in here. But my thought is, if you're going to rest, then what we ought to do before we bring the jury out is I'll have my conversation with Mr. Terry about whether he wants to testify. And if the answer is no, then we could also talk about any directed verdict motion that the defense may have, so that when the jury does come out, I can say, call your next witness, state rests. Will you be presenting evidence? Nope, the defense rests, and we could start with closings. Any reason you don't want to do that, Ms. Smith? Okay, will you be opening and closing?
Yes.
Okay, does that work for you, Ms. Wood?
Yes, Judge.
Okay, all right. And we'll try that out when Ms. Rivers is out here.
Judge, just for that about the closing arguments, I was going to close those, so I'll be reserving my time until after the defense test was in here.
So you don't plan on getting up first to saying a few things. You will simply say, we're going to reserve all our time, and Ms. Wood or Ms. Rios will go first as between the two sides.
That's right.
She'll speak her piece, and then everything you have to say in closing, you'll say at the very end.
Yes.
Got it? Ms. Rivers, let me know when you're ready. Okay, well, let's get on the record. It's 25 SC 001921, State versus Terry. It is Tuesday, the 24th, a little after 9 o'clock. Mr. Terry is here with his lawyers. Good morning, Mr. Terry. Good morning. Ms. Smith is here with Mr. Miller, and I think we are ready to go. Ms. Smith, we didn't wrap up the state's presentation yesterday, even though we had time, because there was the possibility that the state was going to recall Ms. Asia Lynch. Do you plan on doing that?
No, we do not.
Okay. Any other evidence that you'll be presenting? Okay, so when the jury comes back out, you plan to announce that the state rests?
Yes.
All right. Ms. Wood, let's talk about motions for directed verdict before I talk with Mr. Terry about whether he wants to testify. Do you have any motions, knowing that the state is going to rest?
No, Judge.
Okay, I think that makes sense, given the evidence that we've heard. Mr. Terry, I previewed this yesterday, but you and I now need to have the conversation about your decision about whether you're going to testify. You ready?
Yes.
Okay. Do you understand, Mr. Terry, that you have a right to testify, and that if you wish to exercise that right, no one can prevent you from doing so? Your lawyers don't get to veto it. You understand that?
Yes.
Do you understand that in the same way, no one can compel you to testify? If you want to remain silent, the state can't call you, your lawyers can't push you up on the stand to get you to talk. You understand that?
Yes.
Do you understand that in just a couple moments, I'm going to be asking you, and not Ms. Rios or Ms. Wood, whether you want to testify? In other words, it's your decision.
Yes.
Do you understand that if you choose not to testify, I will be telling the jury that they are to draw no conclusions from that fact whatsoever?
Yes.
Do you understand that if you choose to testify, you need to answer, you will be required to answer questions from both sides, not just the arguably easier questions from your lawyer, but you'd also have to answer the cross-examination questions from the prosecutor. You understand that?
Yes.
Okay. Understanding all these things, Mr. Terry, do you wish to testify in your case?
No.
All right. I find that Mr. Terry has made the decision not to testify with a full understanding of his rights, and after he has had an opportunity to consult with his attorneys. Ms. Wood, do you intend on calling any other witnesses?
Sure.
Okay, then we are about ready for closings. I'll give you guys a moment to get organized for that. I saw that a verdict form just came across. Do we need to talk about it before your closings, because you were hoping to hold the verdict form up, or is that something that we could talk about? I'll just print one out and share it with everyone after I give the charge to the jury.
Not necessarily, we just want to make sure that the defense is okay with the verdict form.
Okay, I'll print one out. I may not use yours, not because there's anything wrong with it, but just because I've got a format I use. I just wanted to make sure, sometimes an attorney wants to have the verdict form as part of her PowerPoint. And if yours had something funky, like it says on it, Terry's guilty, we shouldn't use that one. So as long as you're not planning on using your proposed verdict form in your PowerPoint for your closing, then I think we're good to go.
Yes, I do.
All right, great. Ms. Wood, you want 5 minutes before we bring the jury in?
Just to iron out my technical
Okay,
issues.
sounds good. Bless you.
Thank you.
It is, everything is yellow in my yard. Yeah, our garage door is broken, and so we have to leave it up, and everything in the garage has turned yellow. All this stuff, Courtney's furious, like, we have to pressure wash everything. Like, I don't know about pressure wash, but there's pollen on everything.
Reaches.
It's like I did it in the streets.
Get rid of
It's not all.
Mm-mm.
it.
I'll do it further than down for.
Thank you, Deputy Gordon. Everyone can be seated. Good morning, ladies and gentlemen. We're off to an earlier start today. Thank you for being here, all but two of you right on time, but it's not even 9:15 and everyone is out here. The lawyers and I took care of the things we needed to after you left yesterday. So we were good to go as soon as we got everyone aligned. When we ended yesterday, we were still in the midst of the state's case. So I'm going to ask Ms. Smith in a moment to call her next witness. And eventually this morning, the state's going to say we rest. We'll turn to the defense to see if they'll be presenting any evidence. Reminder, no burden on the defense. They have a right to present evidence if they want to. They may not. Once both sides have rested, it's time for closing arguments. After those closing arguments, when the lawyers will attempt to persuade you to decide the case in one direction or the other, I will present you with the law that you must apply to whatever facts you find in this case. I suspect we'll do all of that this morning, and then you will be off and deliberating, okay? Ms. Smith, if you'd call your next witness, please.
Yes, Your Honor, at this time, the state rests.
Okay, so the state has completed its case in chief. I'll turn now to Ms. Wood. Ms. Wood, are you going to be calling any witnesses on behalf of Mr. Terry?
No, Your Honor.
All right, so the defense is resting.
That's correct.
Then the evidence is truly closed, and you've heard all the testimony and received the exhibits that make up the corpus of the evidence you'll use to decide what happened in this case. The state has the burden of proof, and that means that with closing arguments, the prosecution is given a chance to open and close. In other words, get up first, say some things to you, sit down, see what the defense says if the defense attorney decides to give a closing, and then give sort of a rebuttal or have the final word. But the state can also waive the opening and just go last. Ms. Smith, what's the plan for the state?
Yes, Your Honor, the state will be doing a close, which means that we reserve our time until after the defense has presented its closing argument.
Okay, so the state is just going to go last in this process, which means, Ms. Wood, when you are ready, it's time for a closing argument from the defense.
Thank you, Judge. Good morning. Thank you again for being here. Thank you for your attention on Thursday and all day yesterday and for today. I don't think I've said this yet, but you all are actually the most important people in this courtroom, even more important than Judge McBurney, because you're the fact finders of this case, right? So that's why on Thursday, when we were asking you all those questions, and yesterday when we were listening to the questions that you all thoughtfully asked, it's great that you were doing that because it means that you were paying attention. And that's important to me and important to Ms. Smith and Mr. Terry, because it shows that you are engaged, you listened, and so you're going to be ready to evaluate this case as soon as you receive it in back. It's not just going to think you'll get it, I don't know how the place it should be. All right. Judge McBurney has told you the state of Georgia has the burden in this case, okay? So they have to prove this case beyond reasonable doubt. They had no evidence. They had no phone calls. They had no text messages, no records, no proof. Julian Terry is not judging. There's no paper trail. One would expect if someone is trafficking drugs, there would be some sort of paper trail. All the state of Georgia has in this case is the word of 3 lying snitches who are hoping and praying that what they said about my client he's gonna give them a sweeter deal. That's all the state has in this case. Now, I spoke about the indictment yesterday. This is what gets someone into a court, right? So here's the indictment in this case. We already know Mr. Adams has already pled guilty to counts. 1, trafficking in methamphetamine, 2, possession of a firearm during commission of a felony, and 4, reckless conduct. Mr. Terry was charged with unlawfully and knowingly possessing 200 or more grams of a mixture of methamphetamine. He's also charged with possessing drug-related objects. States alleging that he possessed a digital scale. There has been not a shred of evidence in this case. Julian Terry, my client, ever possessed any drugs, that he ever possessed a digital scale. So by law, you have to acquit in this case. I'm going to walk you all through a little chart. I'm a visual learner, so I hope you'll see it down there. I'll read through it. This is a chart that I use in every trial because I think it breaks it down very clearly. So it's the levels of proof. And Judge McBurney has told you the state of Georgia has the burden of proof in this case. Mr. Terry has to prove nothing. The burden of proof for this criminal case is the highest one in all the land beyond a reasonable doubt. That is incredibly high. So if you start down here on the bottom step, no trace of evidence whatsoever. No evidence at all. It's not guilty. If you go up to the 4th step, probable cause, that is reasonable and trustworthy information that a particular person has committed a particular crime. That's all an officer needs to arrest someone, okay? Probable cause. You go up next to preponderance of evidence. It means the greater weight or amount of evidence, the amount of evidence that's needed to win in a car accident case. I know some of you said on Thursday that you've been involved in lawsuits revolving around car accidents. That's all you need to prove one side or another in that kind of case. Then you go up one more step to clear and convincing. That's the type of evidence the state needs to take a child away from its family. Okay, so you think, well, that's going to be something. You go up to the very top. Beyond a reasonable doubt means evidence beyond any doubt based on any reason. It's got to be bulletproof evidence, right? There's got to be no questions. Not a single thought could convince you otherwise. That is what the government has to prove in this case. They have to prove beyond a reasonable doubt that Julian Terry actually possessed any drugs and actually possessed a digital scale. Okay? You would only be authorized to return a guilty verdict and convict Mr. Terry if the evidence excluded all reasonable theories of innocence and proves the guilt of Mr. Terry beyond a reasonable doubt. And I truly do not believe that the state has proved anything of the sort in this case. Now I'm going to walk you through some examples of reasonable doubt in this case. As I said a few minutes ago, there's absolutely zero evidence that Julian Terry ever actually had any drugs in his possession, not on his person, not within his reach. Nothing. There's no evidence of that. There's absolutely no evidence that Mr. Terry benefited in any way from any of these purported drug deals that he heard about from the drug dealers themselves. I want you to really consider that. If someone was involved in drug trafficking, don't you think that they would want to cut of the profit? Wouldn't they want some sort of benefit? I don't think that anyone involved in drug trafficking would do it for free. And there's been absolutely no evidence that Mr. Terry benefited from anything. And why is that? Because he wasn't part of any type of deal. All right, so I want to talk about reasonable doubt witness by witness. And I want to start with the state's star witnesses, the 3 snitches in this case. If you stop and think about it, the only thing connecting Julian Terry to any of the drugs on the scale is the testimony that we heard from 3 people who were actually themselves involved in drug dealing. Now, I really I'm gonna start sounding like a broken record, because I'm gonna talk about this my whole time that I'm talking, but I think it's vital to what we're talking about here, because the only three that connects them to the drugs are the people who actually need something in return for what they say, in return for their lives, right? All three of these people need leniency. We heard from Asia Lynch. What she's charged with, or she's not charged, I'm sorry, what she admitted to on the stand, she can still be charged with. Statute of limitations would not cover that. So of course, she's gonna say something that would help her, that would benefit her. The confidential informant, we don't even know who he is, other than that he's in a federal prison somewhere. We do know that he got a benefit from what he said against Julian Terry. And we do know, both investigators said the only reason they even started this investigation, if you will, against my client is because the confidential informant said, hey, look over there, look at that guy. And then we have Mr. Adams, who you know, in plea, not even a week ago. And whatever happens to him, whatever sentence he receives, is writing on his testimony in this case. He told you that in the stand. And that's huge. That's a big deal. All right. So let's talk about reasonable doubt that we have from the witnesses who didn't actually witness anything at all. The only thing we know for certain after hearing investigator Askew's testimony is that the sky is blue. That is all we know for certain. The video that the state showed while she was on the stand, the upside down video that showed mostly just the blue sky, proves nothing at all. We never saw any drugs. We definitely didn't see them in Julian Terry's possession. She could not tell us anything meaningful because she personally didn't see any transactions take place. She even told us from where she was in that parking lot, her view was obstructed by other vehicles. That's huge. She's literally basing what she thinks happened on what a confidential informant told her. I think that's such a big deal. That's why I'm going to keep talking about it, because she didn't actually witness a transaction. She wants you to take a convicted felon on his word. She wants us to believe with certainty the guy who admittedly is getting sentence reduction on his federal sentence for what he said about this case. That's huge to me. She's an investigator. She has the power to take out search warrants, to conduct independent investigation. But she didn't. She didn't look for text messages. She didn't look for meaningful video footage. She offered absolutely no proof to us that Julian Terry possessed drugs or participated at all in any of these drug deals. And that's because she has no proof. All right, our next witness who actually didn't witness a thing at all. Asia Lynch, she clearly did not want to be here at all. She made that clear the way she was handling herself on the stand. Asia Lynch was a drug dealer. She got on the stand, she told us about her own crime. But most importantly, she told us what she testified about. She told us Julian Terry was not there, nor was he involved. She admitted she knows she can still be charged in this case if the state decides to. So of course she's going to say whatever will benefit her to be safe on skin. She offered no text messages, no proof of phone calls, no videos, no cash out records, no proof of any purchase of a financial gift card or anything of the sort. Nothing. Again, we are supposed to rely on the word of a drug dealer. All right, Winkler Adams, he's the state's witness with everything to gain from favorable testimony against Julian Terry in this case. He's a convicted felon, he's a convicted drug trafficker, he will say anything to get a lighter sentence. Please, please, please hear me out when I say this. He entered a plea to trafficking methamphetamine. He has not been sentenced yet. The only way that he can get, he said this on the stand yesterday, the only way that he can get a sentence that deviates from a mandatory minimum amount of prison time is if the state of Georgia agrees to give that to him. And that is huge. I know, like I said, I sound like a broken record, but that is huge. Because of course, he's gonna say anything in the hopes to get a better deal than 15 years in prison. Let that sink in. Use your common sense. Do you really think that he got on the stand? That he is now officially a snitch? Do you think he got on that stand without knowing some benefit was going to be awaiting him? He needed to perform well for the state because he's going to be sentenced after this trial. It's plain and simple. He will say anything to benefit himself. We also know from his testimony that he himself brought the drugs to the Home Depot that day. Mr. Adams is the only person we have proof of possessing the drugs. And he told us that he had the drugs. He came to the Home Depot in his vehicle, with his firearm, with his little girl, and with over $10,000 cash money in his pockets. My client doesn't even have a car. In her testimony, he rode with the other guys in a Corolla. Adams is clearly the drug trafficker here, not Julian Terry. He had no proof of text messages, no phone calls, no cash app receipts, nothing. And I would submit to you all that it is 2026. The internet is forever. People have records of Instagram messages or Facebook messages. If they existed, where are they? All right, next, let's talk about Sergeant Charles. He did not actually witness anything either. We know that from his body camera footage, from his conflicting testimony that he gave. He even showed up to testify as the lead investigator in this case, in a drug trafficking case, without a copy of his police report. I don't think he reviewed it before he walked in there, to be quite honest with you. He, at one point, confused Winslow Adams with Julian Terry for the early August incident that he described, which, if you recall, I refresh his recollection, Mr. Terry was not there. The state even tried to clear that up. You mean Mr. Adams? No, he was sure. And then, I helped him out by showing him his report that he didn't even bring. He had no idea who actually placed the drugs on top of the Corolla because he didn't see anything. Because we know from his body camera footage that he was not on the scene. Everything that he testified to yesterday is speculation. He didn't witness anything. Again, he's trusting the confidential informant. He's basing what he said off of hearsay from a guy in federal prison. At one point, he also said that he saw Julian Terry with the bag, but we know that's incorrect, that that's a lie, because from the body camera, we also know, like I just said, that he got there after the fact, so he didn't see anything. He has been an officer for over a decade. He admitted the importance of documenting everything properly, attributing everything in the report to who it goes to. He could have gotten search warrants to investigate anyone's home. He could have used a search warrant to get every phone of every single person that was arrested there that day. But he didn't do that. Why not? This case happened over a year and a half ago. August 2024. He's an investigator, but he didn't investigate anything. He literally built this case off of hearsay. He wants us to trust the words of the snitches. He admitted he never saw Julian Terry possess the drugs. He also admitted on my cross-examination, he never found a scale on Julian Terry's person. He offered no text messages, no phone records, no screenshots, no videos, no bank records, no proof. The only thing that he did get accurate, and I believe it's because it was written down the day of the incident, and this is Defense Exhibit 1. Officer Patrick Charles entered into evidence MDMA pills from Wyncliffe Adams. Again, there is no proof in this case. There is no confirmation. No one did any follow-up to see, hey, is what this confidential informant, is it true? Where is the proof? These investigators, we had 2 investigators. None of them did anything to verify the words of snitches. I find that to be hugely problematic, not just as an attorney, but as a citizen, right? This is America. They have the ability to do it. Why not investigate? Before I move on, I took out, this is some jury charges, but I do want to back up and just throw this out there for you. Is this justice? Is it justice for us to rely on the words of 3 people who are all saying what they need to say to receive some sort of benefit from the government? Is this the system that we want for ourselves and our community? The answer is no. The state has to prove beyond all reasonable doubt that Julian Terry possessed drugs, that he possessed a scale. They haven't proved anything at this point. We have no clue what was actually said between the CI and Mr. Adams that day. We have no proof of anything. And so I'm pointing out, there you'll get all of the jury charges, but these are the ones that I want to bring to your attention. So to sum it up, this jury charge basically says the state needs more than what they've shown us here to get a conviction under the law. They simply do not have it. All right, this is another jury charge, Nancy granted witness. There's a quote from Maya Angelou: when people show you who they are and believe them the first time, I want you to believe the 3 stitches for what they are. They're liars, okay? They are liars. Like I've been saying, all the state has is their testimony. There's no actual proof here. All right, this is another jury charge that you'll hear more about. Basically, grave suspicion, right? You cannot convict Mr. Terry based on speculation or based on maybe, or, it looks really bad on paper. That is not enough. It's not sufficient to authorize a conviction. I'm highlighting these jury charges because you're going to get the jury charges, or you're going to get the law from Judge McCartney after the state closing. And I want you to be thinking about that when you begin your deliberation, when you apply the law to the facts, determine the truth of what happened here. All right, so Ms. Smith asked you yesterday, please use your common sense. I'm asking you to do that now. Common sense. Mr. Terry is not a drug trafficker. He had no money on him that day. The actual trafficker did. over $10,000 in cash. $10,000 in cash money. That is huge, right? No one carries that much money around. He didn't have money on him. He didn't have the drugs in his possession. He didn't even have a car. He's no kingpin. He was at the Wind Depot on a really bad day to be there with some other people. But the state hasn't proved that he's done anything else. The state always likes to tell jurors in these cases that this is your time to make sure the community is safe and justice is served. I want to remind you, this is your opportunity to make sure that the justice system is right. We hear all the time about wrongful convictions. And I pray that doesn't happen here. This is your opportunity to hold the state of Georgia to their burden and make sure the system works as it's supposed to be. To make sure an innocent man does not go down for something he did not do. Now, to be completely honest with you all, I'm a nervous wreck right now because this is my one and only chance to speak to you all. And I know from past experience, I'm gonna go sit down and I'm gonna think about all the things that I should have said to you. And probably later this week, I'm gonna wake up at 3 a.m. and think about all the things that I should have said to you. That happened this morning. I thought about all the things I should have said yesterday, so I know it's gonna happen. But I just want you all to just think about, where is the proof in this case? There is none. The state simply has not proved that Julian Terry possessed anything at all. They didn't prove it because it didn't happen. The state has just not met their burden, plain and simple. Now, after you consider all the facts and circumstances of this case, if you are left with a single question about what happened here, any question at all, if your mind is unsettled, if you're wavering, if you're on the fence, you have to, by law, you have to return a verdict of not guilty. Because if you have questions, then that means there is reasonable doubt. And that means the state didn't prove their case. I believe they have not met their burden. I believe they didn't provide any proof because there is no proof, because Mr. Terry is not guilty of drug trafficking. He's not guilty of possessing a scale. This is your chance to make sure that Julian Terry goes home with his family tonight. I ask that you do the right thing and return a verdict of not guilty. Thank you.
Thank you, Ms. Wood. Ms. Smith, when you're ready.
Good morning, members of the jury. Thank you all again for being here. We appreciate it. You all have sat through an entire trial, heard a lot of evidence in this case, and now it's time for the trial to come to an end. So I have to talk to you all about some legal things first. I'm just gonna get into the evidence that we heard today, but first we gotta go through a couple of things that you all have to know. But kind of just giving you all the timeline, because I told you from the beginning, I don't want to confuse you. I want to keep it as simple as possible. So we'll go over you all's duties as jurors. We'll go over the legal principles. We'll talk about the crimes that are charged in this case. Then we'll get to the evidence. First, let's talk about your duty. As jurors, you have to think about the statements you heard today, the expert testimony, things that just make sense, the elements of a crime. You also have to think about the documents you may have, videos you may have looked at. Then you think about people's motives in this case. All of that is important. But what we don't think about is the passion that may be coming from the side, public opinion, your opinion of the police or law enforcement as a whole, the public feeling about anything that came up in this case, any sympathy for the defendant, prejudice, your disagreement with the law, and any penalty or punishment. It's not for you to decide. In fact, the judge will give you all jury instructions when it comes to what you should and should not think about going into deliberations. So again, when we listen to the evidence in this case, the statements, what you all heard, what you saw, those are the things that you pay attention to. Those are the things that's the most important. Now, the legal principles in this case. The burden of proof. Just heard from the defense, and they said if there's one question in your mind about what happened today, you must have quit. That's not true. In fact, the burden of proof rests with the state, and we said that from the beginning. We're confident that proving our burden in this case, and that we have to prove every element of the crime. However, the legal assumption until the state proves beyond a reasonable doubt is that the defendant is innocent. However, it doesn't mean exactly that after you hear all of the evidence in this case, the defendant is no longer presumed innocent. That's the most important part. We tell you in the beginning, these are the charges that the state filed, he's presumed innocent. But once you start hearing the testimony, looking at the videos, people taking the stand, it kind of goes out the window. Then we're going to talk about different ways or different types of evidence in this case. You have direct evidence, and that's testimony from the witnesses when they tell you what they saw, what they heard, what they felt, and even more. That's direct. That was in your face. That's what the state presented to you all today. You have tangible items like photographs, videos, and documents. And the direct evidence in this case, just to remind you, was the testimony from Mindy Askew we heard from, the testimony from Sergeant Patrick Charles. We heard from Agent Lynch. We also heard from Cliff Adams. And lastly, we heard from Natasha Upton. That's direct evidence. I know the defense said we gave you no evidence in this case, but it's clear that there's 5 examples there. Only big. And another type of evidence is circumstantial. And that's when you're using direct evidence, like that testimony I was just telling you about, to infer other facts and reasonable and justified in light of your life experiences. So that's the things you may not actually hear, but can infer. So we're all using our common sense here. So you have direct and you have circumstantial evidence. You have reasonable doubt. And defense said if you have one question, then you must have acquitted. You have to find them not guilty. But like I said earlier, that's just not true. Members of the jury, what reasonable doubt means is just what it says. Reasonable. Based on your common sense and reason, and not vague or arbitrary. The doubt for which the reasons can be given, you have to think, is it a reasonable doubt? Not if I just have a quick question about was the phone upside down or not. That's not neutral. And I wanted to make that clear because when we're looking at unreasonable doubt and reasonable doubt, well, you have to pay attention to what it actually says. Some examples of unreasonable doubt is non-existent or unpresented evidence. So if you didn't hear it today, it can come up in yesterday's trial. That's unreasonable doubt. How can you doubt something you never even heard? Another example, speculation. Something if you feel like, well, I had a question about it. Maybe I'm just going to think about the answer on my own. You're speculating, you're bringing your own opinions in when it comes to what was versus what was actually given in today's trial or yesterday's trial. That's speculation. And also unreasonable doubt. Now, when we talk about reasonable doubt, that's based upon common sense and reason. Like, for example, the defense says, Julian Terry never possessed the drugs. Members of the jury, based on your common sense, how did the drugs get from Mr. Adams' car to the CI? That's what I'm talking about. Can't be anything that's vague or arbitrary doubt, and doubt for which reason can be given. That he stood in front of you with so many holes, you don't even know how they got to the wing depot that day. That's reasonable doubt. But the state gave you that evidence too. And I talk about reasonable doubt a lot because this is the burden the state has to prove to them. And you saw the defense's chart, it's pretty high up. And I understand that when people hear reasonable doubt, they're like, there's no doubt in my mind, I can't have any other thoughts. I just want you to know that when it comes to reasonable doubt, it has to be reasonable. And you're going back to the same things we talked about earlier, that you have to look at the statements, you have to look at the documents, you have to look at what was presented to you. Not something never going to brought in the trial. So again, we're not looking at unpresented evidence We're not looking at the comments of the attorneys that were unrelated to the trial. We're not worried about it. We're unhappy with police and had law enforcement coming in. Reasonable doubt is not speculation. Reasonable doubt is not sympathy for the defendant. Well, he looks pretty sad. That's not reasonable doubt, members of the jury. Prejudice. We're not looking at if you disagree with the law. I don't think this is right, so they didn't prove that verdict. It's not what we do. And again, penalty and judgment. You don't have to think about what happens after you give your verdict. And Judge Vernon will give you some instructions on that. But that's not to calculate on if there's reasonable doubt or not. It's not a part of the burden that we have to prove today. Now, when you look at this, and I don't need your responses, but I see a dollar bill. But there's a couple of pieces that are missing. I don't know about my flash not working. It's going to top. It's okay. We got some holes. We got some other pieces that's missing. We can all clearly see that it's a dollar bill. It's Thursday. That's what reasonable doubt is. So if you have a question about, well, you know, how many cars are there? Or what time did they actually show up to the scene? That's a missing piece of the puzzle. But it's not reasonable doubt. It's not a reason you say, oh yeah, he's not guilty. We don't know how many cars were at the scene. He's not guilty. We don't know how many plainclothes officers were there. He's not guilty. Because one of the police officers said even though they had constant communication with their team, he drove up at the last minute. That's reasonable doubt. It's just a missing puzzle piece. Because ultimately, the case that the state gave you all today gave a clear picture on who possessed methamphetamine and who was trafficking in methamphetamine. You know, we talked about you guys' role, and I've thanked you all probably 100 times because that's how I feel. You all are here to do a job. Some of you all for the first time. And it may seem like a lot because we're asking for a verdict in this case. We're asking for you to go back and look at all the evidence and make a really real decision. But the jury determines the credibility of the case. The jury determines who should you believe or who you should not believe. It doesn't matter what I stand up here and say or what the defense thinks. They come up here and say, well, there was 3 to 4 snitches. That's comparison. You decide who's credible and who's not. And hopefully through testimony and argument, you're able to see exactly what the testimony is credible about. Now, you'll get a lot of jury instructions from the judge, and I can issue that a lot now, but one of those comes single witness. And that's the testimony of a single witness. And what that jury charge I want to say is that if believed, it is sufficient to establish a fact. For example, Sergeant Charles said, we know that Julian Terry took the drugs from Wincliffe Adams, had them in his possession, and walked to the CI. Well, that's a single witness. It was testimony. And it is sufficient to establish fact. So then one of the jury instructions that we'll get into. And we've got through the legal principles. We can breathe. That was the law part, right? We talked about reasonable doubt. We talked about our burden. We talked about the things that we have to prove to you and to what extent. But now let's get down to the crimes that Julian Terry is actually charged with in this case. He's charged with 2 counts. The first count, and this is a copy directly from the indictment, is trafficking in methamphetamine. And what the state has to prove is that the defendant unlawfully and knowingly was in possession of the methamphetamine. That's what we have to prove for trafficking in methamphetamine. That Julian Terry possessed it, that what he possessed was methamphetamine, and that it was over 200 grams. We're proving that, members of the jury. And I made a chart to show you how. I'm going to start with possessed. We got a testimony from Sergeant Patrick Charles that it was Julian Terry who went to the car of Wincliffe Adams. At that time, Wincliffe Adams took the drugs he had and gave them to Mr. Terry. Now, at that point, members of the jury, he had it. Julian Terry had the drugs. He possessed them. They were in his possession, in his hand. And he knew exactly what they were. I mean, he set up the meeting. He told Wincliffe Adams what to bring. So when he got that bag from Wincliffe Adams, he didn't think it was a cheeseburger. He knew that it was methamphetamine. He knew that it was drugs. And he held it. And not only did he hold it, members of the jury, he then got out the car and walked across the parking lot to hand it to the CI. That's possession. That's you being in control of something that's in your hand. And when it comes to possession, members of the jury, it doesn't always mean that you have to actually have something in your hands. It can be constructive. What that means is you have knowledge. You have control over what these drugs or items may be. So even if in some world you didn't have the drugs, you still knew they were there. You still knew what they was. And for some reason, in some kind of way, the drugs got to the CI. So I tell you, when we talk about possession, that element has been proven. There's no doubt. And it wasn't just Sergeant Charles who said Julian Terry had the drugs. Then he asked me to testify to it. And Wycliffe Adams, the co-defendant, the only other person in the car with Julian Terry, told us he had the drugs. We're not limiting what Wycliffe Adams did, but he's not sitting at that defense table over here talking about Julian Terry. And once it went from one person to another, that's when it was in his possession, members of the jury. Now, the other two are kind of a little bit more simple to explain. We heard from Natasha Eklund, who came in, she said she tested drugs, tested a lot of drugs. And they came back with methamphetamine, over 200 grams. We heard that from the expert. So when it comes to just these three elements the state has to prove for trafficking in methamphetamine, in my mind, it's check, check, check. He possessed the drugs. He had them in his possession. Then when they sold them, the drugs were methamphetamine, and it was over 200 grams. Now, the next thing that the defendant in this case is charged with is possession and use of drug-related objects. Again, this is a copy and paste of the indictment, so I'm going to go to the back of the law. But in this indictment, it says that Julian Terry is charged with unlawfully possessing with intent to use a scale and object for the purpose of packaging methamphetamine. We showed you evidence on that. Sergeant Charles took the stand and told us, after the defendant and the other four people at the scene were arrested, they searched the Toyota Corolla that Mr. Terry came to the scene. And on the same side Mr. Terry was sitting on, there was a scale. And it wasn't a full scale, it wasn't weighing apples, and it wasn't weighing oranges. Members of the jury, he believed he was going to weigh that methamphetamine on the scale to the PI. That was the reason for the scale. And he said Julian Terry had it because it was on his side of his car, not his car, but the car that he was in. Members of the jury, when you're dealing with so much methamphetamine, you have a scale, you have to think, well, what is the correlation? Well, usually there's something. And we heard from Sergeant Charles, he said that these type of small scales that was found at the scene, they're commonly used when it comes to distributing drugs. You need to weigh it, you need to know how much it is, you gotta make sure what you're getting your return is actually for that exact amount. So possession and use of drug-related objects, even if he wasn't using it at the time the officers searched you. So Julian Terry searched you, he didn't have a scale on. Well, that doesn't mean he's not guilty of the charge. That just means he either intended to use it or at that time it was. Now the evidence. And yesterday was an entire day of testimony. And we're going to go through that testimony one by one. But I want to make sure that what we heard is pretty clear. We heard from a couple of witnesses. And when I say a couple of witnesses, I mean, I believe the state gave a star-studded lineup. We gave you all the TFO agent who worked directly with the CI, who can testify to the communications the CI had with the defendant, who was there on the day of the takedown. We gave you all the lead detective who oversaw this investigation from the beginning. I mean, we gave you all the co-defendant, the person in this case who was the only person in the car with Julian Terry at the time he pulled up and gave the drugs to Mr. Terry. We also gave you Agent Lynch. And just like the bench said, she didn't want to be here. I mean, she had been friends with Mr. Terry for so long, when they finally fell out, she wants to come and testify about that. And even though she didn't want to be here, remember, the jury will go through it. But she told us exactly Mr. Julian Terry told her to do. So we're going to start with TFO Ashley, Task Force Officer Ashley. She took the stand and she told us that this investigation started because she got a tip that Julian Terry was selling dope out in South Fulton, which we found out to be true. And she informed the South Boylston Police Department. They partnered together, started an investigation into Mr. Terry. And that eventually led them to August 28th, 2024. But there were other prior incidents before. But what Ms. Askew testified about was the continuous communication between the CI and the defendant. They talked a lot of the time. If the CI wanted something, he reached out to Mr. Terry. And Mr. Terry made sure that he got it for the CI. See, that's what Ms. Askew told you. That's what we talked about when she got on the stand. She told us that she was the CI handler. She wasn't just a fifth person on the squad that overheard what was happening. She was working with the CI. She overviewed what he was doing. They debriefed and post-briefed when he went to go meet with the other people Mr. Terry sent to sell drugs to. She had a very close relationship with the CI. This isn't secondhand knowledge. She worked with him. She was able to oversee every conversation that he had, CI, with Julian Terry. This relationship between Julian Terry and the CI didn't just pop out of nowhere. It had to be communicated somewhere. They didn't both just show up on August 28th to go get wings. It was like, I got a question. It didn't happen like that. They knew each other prior. And that's what Ms. Askew told us on the stand. Now, on cross-examination, we did get into the CI and the sentencing recommendation. And I know it's like, oh, did he have a motive to lie? I'm telling you, he didn't. He didn't lie. He didn't do this to get a benefit because everything that he told Askew, well, that was corroborated. When he said, I talked to Julian Terry, he told me to meet him on August 28th to get methamphetamine. Well, on August 28th, he met with Julian Terry to get some methamphetamine. When he said, I talked to Julian Terry, and he's going to send somebody else to me to come sell me the drugs, well, he went to that location with a person that Mr. Terry sent, and he was sold drugs. So it's not like this person just started this investigation with the incentive of, I'm going to do everything in my best to get a sentence reduction. What happened was they used a reliable CI who reported back on everything he heard. Now, unfortunately for the defense, those conversations were with Mr. Terry. Now, we watched the video yesterday, and for the most part, for all part, you couldn't hear anything. But we saw a couple of things, and it wasn't just at the stop. We also saw Julian Terry multiple times. And after we saw Julian Terry, there was an interaction where money from the CI was being given to Mr. Terry. And it was unfortunate that we couldn't hear anything, but guess what? We had Ms. Askew here to narrate, and she told us. They stood around for around 25 minutes just to wait on Mr. Adams to get here. Members of the jury, Mr. Terry was there. The CI had never met with Mr. Adams. So I'm wondering, how did the drugs get to the CI? But in this video that we watched, Ms. Askew narrated that Julian Terry walks to Mr. Adams' car, walks back, and that's when you see the money being given to Mr. Terry. Now, of course, he is a confidential info. Let's be real here. He's not going to have a camera like this. Smile. That's not going to happen. He has to be realistic. He's playing a role. So, of course, he's only going to show the sky at certain times. He's going to be down in the ground. Occasionally, he gets Julian Terry on the camera. But if we're being real here and using our common sense, that wasn't going to be the best video ever. It was going to be a realistic video of a confidential informant working with police officers during this drug trafficking case that we're talking about here today. Now, we also talked about age limits. Her testimony was short, maybe 5 minutes. And of course, like I said earlier, it was clear that she was past friends with Mrs. Terry. Things went south, and now the state is calling her to testify in this case about a previous arrangement between her and Mr. Terry. She's not going to be happy about that. But she wasn't sitting up there mad because she had to lie about something. What she told us was that Julian Terry contacted her to go sell drugs on his behalf. Julian Terry directed her to go and sell the illegal narcotics to the confidential informant in this case. Julian Terry told her where to go, what time to be there, who she was meeting with, how the person looked. I mean, down to the T. He set that meeting up. She wasn't the drug dealer in that case. She sold them drugs, yeah, but he went on the direction of Mr. Terry. Those weren't her drugs. And she told us that when she left, she sent the money to Mr. Terry. She got money for dropping it off. It wasn't her deal. members of the jury. She was directed by Mr. Terry to go there and sell to the CI. She told us that she was down on her luck, right? She needed money and that's why she did it. Mr. Terry, yeah, the guy he is, put her in a situation where she could make money. It wasn't the other way around. And that's what we got from Ms. Lynch on yesterday. And then we talked to Wincliffe Adams, co-defendant in this case. And members of the jury, he admitted that on August 28, 2024, he was there to give Mr. Terry some drugs. That's true. But he didn't stop there. He told us the whole story. Well, after I did my part that I'm taking accountability for, I handed the drugs to Mr. Terry. Mind you, these are the only two people in the car. Minus his daughter that was in the back. We're talking about adults here. This was adults that was in the car. And he told us that prior to August 28, 2024, he did another deal for him. That was before August 28th. And at that time, Julian Terry reached out to him. Just like he did with Agent Lynch. Julian Terry told him to go and sell some illegal narcotics to the CI. Again, just like Agent Lynch, Julian Terry told Wincliffe Adams where to meet the CI, what he would look like, what he would probably have on, how many drugs or how much drugs to bring, how much money to expect back. And after Wincliffe Adams left that cell, he gave money to Julian Terry. See, Wincliffe Adams was used as a middleman, a person that can go and do the job when I can't. Wincliffe Adams told us that the only reason why Terry didn't make the deal himself was because he was out of town. You know how much of an importance you have to be for somebody to agree to go to a drug sale for you because they're out of town. So the thing is, when Wincliffe Adams took the stand, he told it all. He told it himself. And he told everyone in this room how everything actually went. Now, that was the situation that happened prior to August 28th. But on August 28th, 2024, he told us that Julian Terry reached out to him again. One time wasn't good enough. He reached out and told him, hey, I need you to come to this location. I need drugs. I need this much of it. Let me know when you're there. That's what happened. See, Wincliffe Adams told us, he pulled up at the scene, but he never got out the car. He didn't even know who was there. He never got out the car to interact with anybody else but Julian Terry. And that's the most important part. And to be clear here, this crime of trafficking in methamphetamine did not stop once Wincliffe Adams gave Julian Terry the drugs. His part was done. But then Julian Terry took the drugs in his possession, and that's when his crime started. Not placing the blame on just one person because they took accountability and said, yes, this is the part I did. What we're doing is trying to hold everybody accountable for what they did. And in this case, Julian Terry had possession of those drugs, and on cross-examination, I mean, he was asked a lot of times about, do you know what the mandatory minimum is? Did you take a plea? Do you understand the parameters of your plea? And as you heard from Wincliffe Adams, he was very clear. He took a plea. He didn't have his sentencing yet. But that he knew what he was facing was the mandatory minimum. And to be honest here, when you get the indictment, you'll see that there are more charges that Wincliffe Adams is facing than the defendant. Meaning that he's facing even more time than the defendant. What is his incentive to lie? There's no motive for Mr. Adams to lie in this case. He was charged with trafficking methamphetamine too. And when he took that plea, members of the jury, he didn't get a reduced charge. We didn't say, we'll charge him with the intent to distribute. He pled to trafficking in methamphetamine. See, the only difference about Wincliffe Adams and Julian Terry is that Wincliffe Adams took accountability for what he did. And we refer to Wincliffe Adams as if he's on trial right now, but he's not. Only one person sitting at that table. So when we talk about Wincliffe Adams and his motive, we gotta be clear that it wasn't a motive. He said on the stand and told everyone that the state has not given him the deal, any leniency, any promise. And we've made that very clear in exchange for his testimony. What he did was already take accountability for what he did on what day he took the stand to let the jury know exactly what happened. So it's kind of tough when we talk about Wincliffe Adams because he was mentioned so much throughout the trial and even during the defense's closing. But the truth of the matter is, there's only one person sitting at the defense's table, and it's not Wincliffe Adams. And that's because he admitted to what he did. To what he did. Now, we heard from Sergeant Charles, lead detective in this case. And he told us about how the investigation went from the beginning. He received a reliable tip from the FBI task force agent Askew, who told him, my CI has informed me that Terry is selling dope in South Fulton. And like I said in my opening, that's right down the street, our community. So when he got that tip, as a police officer of South Fulton, he investigated. He did what he was supposed to do. Those control buys, they set that up. The day of the takedown, they set that up. They made sure that before they moved in on Mr. Terry or anybody else who was with them, they had the evidence. They weren't just gonna say, Julian Terry, okay, checks all the boxes, let's go get him. Julian Terry committed a crime. And that's why South Fulton arrested him. And when we talked to Sergeant Charles, he told us, just like Askew, the CI and the defendant, they communicated to conduct buys of illegal narcotics, and not just on one occasion. The only thing is the first 2 times he wasn't available. So he sent somebody else. But Julian Terry was at the center of every single one of those buys we talked about on yesterday. Agent Lynch, with Wycliffe Adams, and the takedown that happened on August 28th, 2024. Everything flowed through Julian Terry. And I don't want to have the jury distracted by the what ifs and what may have not came or what came out, what didn't come out. What did come out was that every single time they met up, Julian Terry set it up. Every time there was a controlled buy in this investigation, Julian Terry was the one who either went there himself or told someone where to be, at what time, how much of the drugs to bring, how much you should get in return, and make sure you bring me back my money. Sergeant Charles told us that on August 28th, 2024, Julian Terry waited for Wycliffe Adams to get there over 25 minutes. He waited. And that whole time he was talking to the CI. They talked about it, conversations, whatever the case may be. But then he told us through his communication of being there with his officers, and let's be real for a minute, this is a takedown, right? This is the day that they're going to go and shut down Julian Terry's operation. You think they're going to be in the parking lot and marked cars looking out the window like, go ahead, do it? No. They're going to be in disguise. You're not going to see them, and if you do, you're not going to know they're officers. So because Patrick Charles was on the side of the building while he was listening to comms as it happened in real time, and every time something happened, he was notified of it, that doesn't make him less of a witness or less of being credible members of the jury. He was the lead detective. He knew what was going on. He knew that it was Julian Terry who walked to Mr. Adams' car, got those drugs after getting the car, nothing in his hands or his pockets. But then getting out of the car with the drugs in his hand, that was Julian Terry. We talked about the property log in this case. Now, I cleared up on redirect that the reason why Wycliffe Adams' name was there was he was the person who originally had the drugs. But on that property sheet, we only focused on the name. I wish I could bring it back up, but the description says the bag found on top of the Toyota Corolla. Mr. Adams was driving an Explorer. Don't get distracted by these little things that the defense may try to bring up to try to poke holes, because that's their job, to poke holes in our case. But the truth of the matter is, Wycliffe had them first. We're not hiding that from you, members of the jury. Then he gave them to Julian Terry, who did have it. Wycliffe Adams was charged with having those drugs and giving them to Wycliffe. Giving them to Julian Terry. So once Julian Terry took those drugs for himself, that's when he started his trafficking and methamphetamine crime. Sergeant Charles, he told us that the drugs that he had, that they were requested by Wycliffe Adams. Again, I don't want to be a dead horse, but the reason why I think they're on August 28th is because Julian Terry said that. The only thing he was doing, he went to Wycliffe Adams' car was to retrieve the drugs that he had already requested. It wasn't blind knowledge. Julian Terry knew what he was doing. And then I asked Sergeant Charles about the quantity. He said, could this be for personal use? He said, no. Personal use is 1 or 2 pills. Members of the jury, we're dealing with over 200 grams of methamphetamine. And like I told y'all in the opening, I'm not a mathematics person. That's a lot more than 2 pills. And I'll show you in a second just how much of that methamphetamine they had. It wasn't used for personal use. So Terry wasn't kicking it up to use it himself or give it to the CI person. This was a large amount, a large quantity, an amount so much that you're charged with trafficking and that means this was intentional. Nobody went in and said, I'm just gonna hand something to the CI. I don't know what it is. It was very clear that it was a lot of drugs and that they were methamphetamine. During trial, we talked a lot about the other people that were there at the scene. And what we know is 5 people got arrested that night. When Adams and Julian Terry were arrested because of trafficking and methamphetamine charge. However, those other 3 individuals that arrived for Mr. Terry, well, they were charged accordingly too. The law enforcement officers, they didn't pick and choose who they wanted to charge because one person was a part of this investigation. It didn't happen like that. Sergeant Charles told us that those other 3 individuals were charged with marijuana because that's what they had. They didn't have the methamphetamine. They didn't walk to Wycliffe Adams' car to get the methamphetamine. And they didn't carry those drugs to the CI to then sell it to them. The only person who did that was Julian Terry. So we've cleared that up. What happened to the other people, who they came with, and what they were charged with, or whatever is happening with their marijuana charges is not relevant to this case here. Because again, there's not 4 people sitting at the table, there's 1. So yes, it is important what happened with those other 3 people. But the state has already made it clear that they were not the ones that were dealing with the methamphetamine. Julian Terry was. We also saw a body cam footage from Sergeant Charles when Julian Terry was taken out of the car, placed under arrest, and he waited until his car was searched, transported to the jail. Now, in this video, it's clear that Julian Terry was there. We're not saying that. However, also in this video, we're able to see the other people that were arrested with him. We're able to see Wycliffe Adams, and I think the body cam just really makes it real. Like this actually happened on August 28th, 2024. And we were able to kind of get a glimpse of that day, how it was. What's the sun down? What's the sun up? But most importantly, we placed Julian Terry at the scene. And then lastly, we heard from Natasha Eck, an expert in this case. She worked for the GBI. She tested the labs and she tested the drugs, and she told us that it tested positive for methamphetamine and that there were over 200 grams. But I want to point out another piece of her testimony that was probably the most important. We looked at her drug lab report. Her drug lab report was 6 pages. Members of the jury, she told co-counsel A.A. Bush that this is probably one of the testings that's taken her the longest because of so many drugs that was involved. And it wasn't just your plain circular drugs. I mean, these were multicolored, multi-characteristic with some of them were guns, smiley faces, hearts. See, these drugs that we're talking about here, it wasn't just 1 or 2, and I think this makes the point. And this is page 1, 2, and 3. This is page 4, 5, and 6. And I don't expect you to read all of that, members of the jury, but I do expect it to show you just how much of the drugs were dealing with. Because again, this was not for personal use. And when we're talking about methamphetamine, members of the jury, that's a hard drug. I'm not talking about marijuana, shrooms. We're not even talking about cocaine. What we're talking about here is drugs that would definitely harm the community. The community we live in. It's perfect. So I'm already spreading them out over here. I'll be over there in 1 second. These were the bags that were placed on top of the Toyota Corolla. These are the bags that Julian Terry possessed, the ones he got from Wycliffe Adams. And it wasn't just 1 bag. It wasn't just 2 or 3 bags. Members of the jury was talking about both bags. And there's not just 1 pill in each packaging. There's multiple. And I'm sorry I couldn't get a definite number of how many pills were in 1 bag, but gee whiz. This is a lot. And that's just 4 bags. In total, there's 10. 10 bags of methamphetamine that the defendant was carrying. And I'll keep that there so you all can see it, because I want to press on the importance of just how much of this was Julian carrying. How much did we get from Wycliffe? How much was in his possession when he sold to the CI. Those are real drugs, members of the jury. And at some point, we gotta start holding people accountable. And that's basically what we got from Natasha X. Now, the defense got up and they said, what about possession? State didn't prove that Julian Terry possessed the drugs. Members of the jury, we heard from Task Force Agent Axby, who said he had the drugs. We heard from Wincliffe Adams, the co-defendant, who was in the car with him, who said he had the drugs. And we also heard from Sergeant Charles. And they all had something in common. They come from different places in the world, different backgrounds. But one thing they all agreed on yesterday was that it was Julian Terry who possessed those drugs. He got him for Wincliffe chest. I've said that enough. But we're talking about what exactly Julian Terry did in this case. He held those drugs. He possessed those drugs. He carried those drugs to the confidential informant to sell them. We're not hiding anything. We're not hiding the ball. The only thing that we're doing is presenting our evidence and presenting the facts in this case. So who is Julian Terry? Remember at the beginning I said, you heard his name in the indictment. You don't know much about him. And I'm sure you still don't know much about him because the whole defense's closing was about other people. We don't even know if Julian Terry has kids. We don't know what his favorite color is. We know nothing about Julian Terry. That's where I come. Julian Terry is a drug dealer. Simple as that. Julian Terry is a trafficker. That's just the truth. He's a drug dealer who went to the Wing Depot location on August 28, 2024 to retrieve drugs from Wincliffe Adams, to possess those drugs while he walked over to the CI to make his sale. He was in the center of that operation, of that transaction. He had those drugs. And as we heard before, this wasn't his first time dealing with the drugs. He had sent other people before to make drug deals on his behalf. And let's talk about what really happened before the sale. The possession went from Wincliffe Adams to Julian Terry. And while he had them in his hands, he got out and walked to the CI. He didn't have them before. Sergeant Charles told us when he walked to the car, he had nothing in his hands, nothing in his pockets, nothing was bulging. But when he got out of the car with Mr. Adams, he had the drugs in his hand. He didn't even try to hide them. Everybody saw him, pretty comfortable. And after he walked to the CI, that's when he sold those drugs. I want to point out something else. So we're talking about Julian Terry possessing drugs, right? Some people are like, what's possessing? Well, the thing is there's not a certain time limit on how long you need to have something to possess it. Once you have it, you have it. I have a ball in my hand, I hold it for 5 seconds, then I drop it, I still possess that ball. If you had methamphetamine in your hand for 3 minutes and conducted a drug sale, you possessed it. You don't count seconds and minutes here to determine if someone possessed something. The truth is in the pudding. And even if I'm carrying a ball for 5 seconds, carrying methamphetamine for 2-3 minutes, that's illegal. And having 200 grams of it is a lot. Another thing that Julian Terry is the shot caller. That is clear as day. If someone wasn't available to go and make this drug sale, he would send other people for him. Agent Lynch, Wincliffe Adams. These were the pawns that he used to make sure his deal didn't get messed up. He's out of town. But he had someone that can deliver the drugs from him because he was the center of the operation, members of the jury. He was the shot caller. If you needed it, he had it. If you needed somebody, if somebody needed some drugs, he made sure he'll give them to you. That's what I mean by shot caller. He was in control of everything. He set up the meetings. He sent the people to sale. And if he could go himself, as you can see on August 28th, that's what he did. We heard about 3 different drug sales, and as I just told you, all of them were set up and directed by Julian Terry. You can't dispute that. Agent Lynch got on the stand and told you all that. Wincliffe Adams got on the stand and told you all that. Julian Terry sent me here on this date with drugs at this time to sell to the CI. He is the shot caller, members of the jury. And we're here today because of Julian Terry calling those shots. He talked to the CI, CI needed something. He set up his meeting on this particular day. And that's why we're here. The date of the indictment is August 28th. They were at that Wing Depot that day because of Julian Terry. We're not hiding his hand. He's not gonna throw a rock and then hide his hand like he wasn't even there, or that he didn't give the drugs to the CI. Members of the jury who did. Casper, let's talk about it. Now, I want you all to use your common sense. And I've said that multiple times. It's kind of crazy how to say it, but we just have to be realistic about these things. Sergeant Charles was on the scene. He knew about everything that was happening. He's the lieutenant. Askew knew what was going on. She was the CI handler. Agent Lynch, Wingcliffe Adams, the CI, they're called snitches. And I get it, it's coming from defense. My mind, they're the truth tellers. They told us everything we needed to know, and it was corroborated. It wasn't like they did all of this and Julian Terry showed up at the scene. That would have been strange. But Julian Terry came, talked to the CI for a boatload of minutes, then went to Wingcliffe Adams' car to get the drugs, possessed them, and then go back to the CI. He is not just a regular person in the situation. And the biggest thing is accountability. I've said it multiple times, members of the jury, but it's the most important. You can't sit there and act like nothing never happened or that you didn't do anything. And since Julian Terry doesn't want to take accountability for what he did, members of the jury, I have to ask you to do it. At this time, as jurors, you're going to look through all of the evidence. You're going to look through what makes sense and what didn't. And by using your common sense, thinking about the testimony you had and listened to yesterday, you got to start holding people accountable. These drugs are dangerous. Very dangerous. And if they get in the hands of the wrong person, it can be detrimental for them. So when we think about why we're here today, it's not just to throw charges at somebody, it's also to help the community, help the people in it, help our babies, help everybody. Because at the end of the day, with the drugs off the street and the drug dealers off the street, well, the community is a bit safer. Members of the jury, you're going to go to the back and deliberate in a minute. And defense counsel, she said, well, what is justice? What is justice? What does justice look like? Tell you that too. Justice is finding Julian Terry guilty of count 1, trafficking in methamphetamine, and count 2, possession and use of drug-related objects. I appreciate you all being here today. I really do. And when you go to the back, and when you look at everything, the evidence that the state has provided is clear that Julian Terry possessed over 200 grams of methamphetamine on August 28, 2024. And also that scale he had was used and was intended to be used to weigh those drugs he just got. We've proven our verdict, members of the jury. We did not run from it. We welcomed it openly. So now we hand the case to you, and we go to the back, looking at all of the facts and circumstances of the case. The state asks you to return a verdict of guilty in this case. Find Julian Terry guilty because he is. Thank you.
Thank you, Ms. Smith. So ladies and gentlemen, what is left between this moment and the beginning of your deliberations is my charging you with the law that you must apply to the facts as you find them to be. We can take a 5-minute break, and I can do that, or I can start right in. Who wants a 5-minute break? Seeing no hands, you have inflicted this upon yourselves without a break. Let me get the file open, and Ms. Wood, you're closest. If you don't mind popping up here, I have one copy for you and one for the state. Thanks. That's the final version. All right, it's my turn to share the screen. But I'm going to stay up here and not come down to the well. Make sure that comes up. So a few things about this jury charge before we begin. First of all, everything I'm going to share with you is in this document, and you will have this document during your deliberations. So feel free to take notes, but if it gets a little legalistic, and I apologize if it does, but I'm required by law to define certain concepts using certain words. The higher courts say that. My goal is to make this as accessible to you as it can be. But as I said, there are few terms I'm required to use because of appellate opinions. But everything that I'm going to be reading to you is also going to be on the screen. So if you're a visual person, you're welcome to follow along and you're free to take notes. But this document will be with you during your deliberations. And with that, let's begin with the jury charge. If I can get this to go. There we go. A grand jury has indicted the defendant for trafficking in methamphetamine and possession of drug-related objects. And again, this is the indictment. You'll have it with you during your deliberations. The defendant has entered a plea of not guilty. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him until it is overcome by the state with evidence sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove every material allegation of the indictment and every element of each crime, and I'll be telling you what those elements are in just a little bit, beyond a reasonable doubt. There is no burden of proof upon the defendant, and the burden never shifts to him. If the defendant presents a defense, the state must disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It is a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is not a vague or arbitrary doubt, but is rather a doubt for which you can give a reason. And that reason arises from your careful consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering and evaluating the evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if no such doubt exists in your mind, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation about his guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law, which is what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence that you've received. You must then apply the law I'm giving you to the facts you find. You must decide this case based only on the evidence presented during trial. That was the no outside research part. That evidence that you've received consists of testimony and exhibits. Evidence does not include the indictment or plea of not guilty. It does not include anything I've said or anything the lawyers have said to include their opening and closing remarks. Nor does the evidence include questions that were posed. It's only the answers that witnesses give or the physical exhibits. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts she has actual knowledge of a fact, such as an eyewitness. I saw the car run a red light and hit another car. I saw it. That would be direct evidence. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I heard screeching wheels and the sound of metal against metal. That could be circumstantial evidence that there was a car accident, or at least a car crash. It may have been intentional. There's no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use your reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You determine the credibility or believability of witnesses. In deciding this, you may consider the evidence, which you've received now, the witness's manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. In assessing witness credibility, you may also consider possible motives for testifying. This includes any pending prosecution, negotiated plea, grants of immunity or leniency, or similar matters. You heard from an expert witness. Experts are those who, because of their training and experience, possess knowledge in a particular field that is not typically known to you or me, average people. Experts are permitted to give their opinions based upon that training and experience. The testimony of a single witness is generally sufficient to establish a fact. Corroboration is not required if you find the witness's testimony to be sufficient. However, an exception to this rule is made when that witness is an accomplice. The testimony of an accomplice alone is not sufficient to warrant a conviction. The accomplice's testimony must be supported by other evidence, and that other evidence must support the inference of the defendant's guilt, independent of the testimony of the accomplice. The supporting evidence on its own need not be sufficient to warrant a conviction, nor must the accomplice's testimony be supported in every particular. However, the supporting evidence must be more than that a crime was actually committed. It must be sufficient to connect the defendant with the criminal act and must do more than merely cast a grave suspicion of guilt upon the defendant. Slight evidence from another source that connects the defendant with the commission of the alleged crime and tends to show participation in it can be sufficient supporting evidence. A defendant who has no burden to prove anything is not obligated to testify. When, as is true in this case, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence that was offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but is simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Criminal acts must be charged and tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Every party to a crime may be charged with and convicted of the commission of a crime. A person is a party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Trafficking in methamphetamine. For trafficking in methamphetamine, the state must prove that the defendant, number one, possessed, number two, 200 grams or more of, 3, any mixture containing methamphetamine. Possession of drug-related objects. A person commits the offense of possessing drug-related objects when he, 1, possesses with the intent to use, 2, any object or material of any kind, 3, for the purpose of packaging, repackaging, storing, or containing marijuana or a controlled substance. It's okay. Hopefully that person wasn't giving you outside information. No? Okay. Any substance which contains any quantity of methamphetamine is a controlled substance. Ladies and gentlemen, you should consider each of the 2 counts individually. The defendant may be found guilty of one, both, or none of the charges. If, after considering the evidence together with this charge, which is almost done, you should unanimously find beyond a reasonable doubt that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check that option on this verdict form, which you will have for that offense. If you do not believe the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him. In which event, the form of your verdict would be, we, the jury, find the defendant not guilty, and you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing on this form, signed by your foreperson and dated. This is an example of how it's going to look. So that's count 1, trafficking in methamphetamine. If you reach a unanimous verdict of guilty, you would check guilty. If you reach a unanimous verdict of not guilty, you simply check not guilty. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws I've provided you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It's also your duty to report to me if you perceive that a fellow juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are, as I've told you many times, the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of all the evidence. Unsurprisingly, during your deliberations, you must not communicate with anyone outside your group about the case, nor may you conduct any outside research. You have all of the evidence in this case. It would be improper for you to supplement it in any way with outside information. And to assist you in complying with those instructions, Deputy Gordon will be collecting your electronic devices, including watches that talk, while you deliberate. We'll give them back when you're done, but while you're in there, no iPads, no phones, no smartwatches, you guys and the evidence. Going forward, should you need to communicate with me for any reason, it must be in writing. Upon receipt of your question or note, I will confer with the lawyers and share with you whatever response I'm allowed by law to give. And I want to caveat that you may have a great question and my answer may be you have to figure that out yourselves. That's not me being flip or difficult, but there's some questions that I'm not allowed by law to ask. And one answer I will certainly give you if you say, could we have a transcript of people's testimony, will be no. I warned you at the outset of the trial. You don't get to have someone's testimony played back. If you want to have videos played back, we can do that for you, but people's testimony cannot be played back. And that's it. That is the charge of the court. I'm going to ask 12 of you to go back to the jury room. Do not begin your deliberations until Deputy Gordon brings you the evidence, the verdict form, the indictment, and the charge I just read. I need Ms. Osler and Mr. Holloway to stay where you are. The other 12 of you should go to the jury room.
Around the dirt.
You all can be seated. You two are alternate jurors. We don't tell you that in advance because you need to see and hear and process things exactly as all the other jurors do. Had we lost a juror during the course of the trial, one of you would have silently and unknowingly slid into the group of deliberating jurors. I'm going to ask that you two stay here today as long as this group deliberates. If for some reason they don't reach a verdict today, we can talk about whether you could be on call tomorrow to come down here from work, as long as work isn't flying far away, to slot in if we have to excuse a deliberating juror. That can come to pass. A juror could be taken ill. There may be some other reason why I need to excuse one of those 12. And then one of you would join that group. They would restart deliberations from the beginning because you wouldn't have been in there. So fresh start. And then we'd see if that group of 12 could reach a verdict. The silver lining for you two is that you get to keep your electronic devices. You're going to set up in our alternate jury room over there, that door with the little tornado sign on it. And you're free to use those devices as long as you aren't doing outside research. I need you to stay in that same information bubble in case you are pressed into service as a deliberating juror. It would be inappropriate to add to your knowledge base by going online to look something up. And the two of you can talk if you want, just don't talk about the case. Don't say, hey, what would you do if you were deliberating? If this jury reaches a verdict today, after I receive that verdict, I'll bring you all in so you know what happens. We will not forget that you're here. If they break for lunch, you can break for lunch. There are restrooms in that jury room. You're free to circulate in general. You just need to stay pretty close to that jury room so that if we need you, we can find you. Do you have any logistical questions about that? No? If you two will go in the jury room and grab your stuff, Deputy Gordon will get you into the alternate room. Thank you. And Ms. Wood, if you wouldn't mind playing courier again, grab the verdict form. You bet. All right, you all can be seated. Ms. Wood, did you get a chance to look at the verdict form?
Yes, sir.
Any issues with the verdict form?
No.
Okay, any exceptions to the charge that was given?
No.
Okay, there was one hiccup. I hadn't saved the final version, and so venue and party to a crime I had switched, but what I sent Ms. Hansberry wasn't the final version. The words were the same, just went in a different order. Ms. Smith, any concerns with the verdict form?
No, Your Honor, looks good.
Thanks. Any exceptions to the jury charge? Okay. In terms of exhibits going back with the jury, our exhibit list totaled a whopping 5 if we include the defense. Is there anything, Ms. Smith, that you think doesn't, I haven't tried a drug case in a long time. I don't know that the drugs go back there. Probably better that they don't, unless someone thinks they need to. We can let the jurors know if they want to look at it, they can come look at it. So I think it would be, we'd send the recordings back so they know they exist. They can't play them back there. Normally I upload stuff onto the machine there, but my ruling about the audio, it would be most inappropriate if they press play on the CI 37-minute video and got to hear everything like, oh. So we'll send that back with them so they can ask to watch it again, the crime lab report, and then we've got the property form. So I guess those 4 could go back. Any objection from the state?
No objection.
From the defense? Okay, we'll make sure those 4 go back, and the verdict form and the jury charge and the indictment. And that'll be it. If you all will leave one phone number for each side that we can call, that will get someone here, you're welcome to stay here. I'll mute everything. But if you're gonna leave, one phone number per side. You can write it on one of the juror note cards, please. So what exhibits do you have in there? That and 2 thumb drives?
I have one thumb drive.
Okay.
It has all the digits, S1, S2, and S4.
Oh. So you can put that in there. S3 never came in, at least the original numbers. Do we have the crime lab report?
That's 3, states 3.
But I don't, is there a hard copy of it somewhere? Yeah, I mean, it's what you ultimately labeled as 4.
GBI lab report, that's correct.
Right, correct. And so we need that. 3 is the drugs. 3 is the drugs. 1 and 2 are the videos. And we've got a thumb drive that says S4, 2, and
This is all, so I actually changed the number so that it's
Okay.
1, 2, and 4.
okay. And we can confirm when the trial's over, that you've got everything. We just need to get the crime lab report. Yes, please.
And if you could just substitute the drugs for a picture.
You want us to picture of the drugs?
Yeah, that way you can.
Oh, not for the jury. You don't need to worry about the jury. This is later, right?
Okay, thank you.
Ms. Rivers does not want 10 bags of illegal Flintstones vitamins in her office.
So we can send this back, right?
Yes, yeah. And then I don't think, there's some document right there behind the monitor. I don't think that's the crime lab report. Sure, actually, you give it to Ms. Rivers. Great. We can sort that out later. Can I get the verdict form back, please? We are back on the record in State versus Terry. Mr. Terry is here in court with his lawyers. The prosecution is here. And we received a question from the jury. It reads, is there any way the CI could have given evidence? Question mark. Deposition, etc. Is there any way the CI could have given evidence? Question mark. Deposition, etc. Ms. Smith, your thoughts about a response?
A response from the state would be that the jurors could consider the evidence that was presented through trial as far as the video that came from the CI and also testimony that was given by Askew or given by Askew as she was the CI handler as far as depositions or evidence from him. That's as far as they could be presented.
Okay. I don't know that the way I take this question is, why was the CI not here? They just didn't really word it that way. And I'm thinking the answer would be either, I'm sorry, I can't answer that question for you, or no, the CI was unavailable. The answer wasn't yes, he was available, or you would have called him. Or maybe the defense would have, but the defense didn't hide him or anything like that. But the reality is that the correct answer is the CI was not available. We would have had to continue the case for 4 weeks. But that may be TMI. Just because that's the correct answer doesn't mean the jury gets to know it. They might ask, why was there no audio on the recording from the CI? And there is a correct answer, but I'm not going to tell them because I ruled it couldn't come in. So between I can't answer your question and the CI was not available for these proceedings, do you have a preference?
The latter, Your Honor, that he was unavailable.
Okay. Ms. Wood, your thoughts about how best to answer their question?
I like option one.
Okay. Tell me your concerns with option 2.
My initial response is that is not exactly true. The state could have gotten him here. They didn't. I didn't know until yesterday morning where he was. So I object to the second option. I think the answer should be, I can't answer that question.
Okay. Anything you want to say in response, Ms. Smith? I think Ms. Wood is correct. I'm not faulting anyone, but in theory, had this been something that your office had looked into a month ago, hey, what about the CI in this case? And I don't know, again, the latest and greatest with the TUI restrictions. And it may be that because you didn't press to get Askew until recently, you would have been denied that information had you asked. But either way, I think the TUI process could have happened earlier. So it's not quite right to say that the CI is unavailable here. I think the safer answer is to say, I can't answer that question for you. But I want to give you a chance to rebut what Ms. Wood said.
Yes, Your Honor, as stated previously, the state would like the second option because the TUI letter did not stop the state being able to get the confidential informant in this case. When we first reached out to get the CI, we had to go through the proper channels, which was talking to 4 to 5 people. And once we got to the 5th person, that's when he told us that at this time the CI was not available. He called me days later and said, well, it is a process where CIs can be taken to state courts for testifying, but he never confirmed that the CI would be able to be here. So the state did press, the state did look into getting the CI here well before the TUI letter even went out. Even when we, even before we placed him on the short list, the state was trying to get the CI. We went through the proper channels. The reason why we could not get the CI was not because of a fault of our own, but because of the custody that he was in and the process we would have to gone through to get the CI. So saying that the CI is unavailable is not incorrect because he was not available for us to get him. If he would have been available, the state would have gotten the CI.
Well, I hear you, but I wonder if, I know this isn't super realistic given all the cases you have and when you start to prepare things, but if in on January 1, you said, I'm starting the new year. I'm figuring out where this CI is. And so you finally got to person number 5, and person number 5 says, I can't tell you that answer. And you had come to me saying, we really need to talk to the CI, central to this case, that I couldn't have entered an order saying, hey, we're gonna have a hearing and someone's gonna have to come here from the Department of Justice. What do you mean you can't tell us where the CI is? And maybe they say it's a state secret and he's in deep cover. Okay, that's different. But turns out the answer was he's probably down at Lovejoy in federal pretrial detention, awaiting disposition of the case where he's going to plead and try to get credit for the work that he did with this task force. Yes, go ahead.
When we first tried to reach out about the CI, initially, we did not know he was in federal custody. We didn't know that until, going up until a week of trial.
Oh, I understand.
That's when we reached out. So even in our efforts of trying to get the CI, we still don't know where he is. We just know he is federally indicted. The state did the proper protocols to try to get the CI here. Unfortunately, he was not able to be here, not because we waited until the last minute, but because the CI was not going to be able to testify coming from federal court to state court by the time I got to that 5th person.
So Ms. Wood, another true statement is both sides have subpoena power. But I'm trying to strike.
Judge, how would I subpoena a witness that I don't even know? And by the way, he's not legally unavailable.
The state doesn't have that information already.
Okay, I got it. Okay. I think the safer answer in this context is to say that I'm not able to answer this question for them. Because if I give a partial answer of, well, hey, the state tried, then that... we're getting into, there's not evidence in front of the jury about that. The bottom line is they heard what they heard, and you were able to share in both your closings as to what they learned about the CI and from the CI, and that's what they've got.
Thank you.
You're both welcome. I think I'm going to say you have all the evidence about the CI that can be shared at this time, words to that effect. It's a little different, but I don't want to say I can't answer your question. The answer is I can. That's not right. But the truth is they've got the universe of what we're not going to add anything. And so I think the more stock response when they're wanting to get more information about something is that the judge says, you've got all the evidence on this issue. And so I prefer to answer that way. You have all the evidence that can be shared at this time about the CI, something like that. I'm gonna start with the other side. Does that work, Ms. Wood?
Can you read it back to me once more?
Sure. The question was, is there any way the CI could have given evidence? And I'd like to respond, you have all the information about the CI that can be provided at this time or shared at this time, something like that. I don't know that I want to say evidence because it's evidence, they're using evidence as we wanted the CI to testify, and what we're talking about is not evidence, it's procedure. Was he available, was he not? And I don't want to get into availability.
I like that very first option, but I think this is more acceptable in my opinion than.
Just say I can't answer your question?
Yes.
Okay. So I wrote on the back of the card, cannot answer your question at this time. I'm going to give to, so this is on the record, Ms. Rivers, the 10 during trial juror questions. That'll be Court's Exhibit 1. I'm going to have Deputy Gordon return to the jury what I've labeled deliberation number 1, their first question from deliberations. And you all can be back at ease. Ms. Smith got here plenty fast when I called. Mr. Terry, you had left the courtroom, which is fine. Does Ms. Wood have a way of reaching you? Okay, great. No, I didn't have a problem with when you came back. I just wanted to make sure that wasn't just a happy coincidence, but that Ms. Wood had a way of reaching you.
Make sure I'm there.
Okay, it's all good. All right, Ms. Smith, anything from the state before we break again? Ms. Wood?
No, Judge, thank you.
Okay. Okay, let's get on the record. In State versus Terry, it is a little before 1 o'clock. Mr. Terry is here with his lawyers. The prosecution is here, and the jurors have asked, it's more of a request. Can we have the 30-plus minute video of the CI footage at the scene? We didn't put a question mark on it, but that's what they're asking for. I assume that is not Sergeant Charles's body cam, but the video that shows us that this guy was blue. And so normally I'd say they can watch it back there, but they can't because we're not doing audio. My proposal is that we bring the 12 jurors out and ask them, do they want it played from start to finish? Or are there certain parts? I'm not quite sure how they'll refer to parts. You did a great job, Ms. Smith, throughout using both videos, saying here's when we're starting, here's when we're stopping. So they may have some time markers on it, and then we'll move to where it is that they want to see things. Otherwise, they may say, we just want to see it from start to finish. Then as long as you can make that happen without audio, we'll just need to do that again. Whether you want to do it from there or through the less laggy system. It seemed to work fine before. It wasn't laggy, it just was upside down and bumpy because I don't know where the camera was on this guy. Does that work for the state, that approach?
Yes.
Ms. Wood for the defense? Okay, if you could check, I worry that their sandwiches just arrived. They already ate? Oh, I'm glad. Okay, we took a little break to do that. If you could bring the 12 out, please.
So I'm waiting until you get my computer to like.
Oh, okay. Don't bring them out yet. It looked like, oh, that's not a computer. I thought Mr. Miller had like, hey, that's a slim computer. Yeah. So next time you come back, have one of your entourage bring a laptop.
Understood.
Yeah.
Did you know that we are outsourcing people to Floyd County now?
No, I learned that the historic Floyd County Courthouse burnt down yesterday, which was sad. Beautiful building.
Yeah. Beautiful.
No.
Okay.
Do you have people there?
I do. I just emailed Miss Walsh because it's my Hispanic speaking clients.
Okay.
Which is, I'm just trying to figure out if there's someone there that would be nice, like our friends at Oconee Jail, who are very accommodating.
And put them online?
Yes.
So let me know how that plays out, because I will work through the sheriff's team to say either that doesn't work or we need to develop a Zoom buddy, because no one's going to require the lawyers to drive to Floyd County to meet with their clients. The other would be that the sheriff's team has to reallocate, and people who have open cases need to stay here. And maybe if you're unindicted, you go to Floyd County. But there also may be limitations. Floyd may say it has to be, like, we can't have people charged with murder at the city jail. They put some restrictions on that. I don't know what Floyd has said. But that's new. I'm gonna find out how many people are there.
Thank you.
So they have a verdict.
Oh.
They don't want to see the video anymore. Were you guys hanging out in there?
AC.
Okay. There should be alternates in there. Wonder where they went. Sitting in that jury room right there. 2 people? Well, I mean, you were just in there. If there weren't people in there, they weren't in there. Okay. Oh, Gordon maybe lost them.
Oh, he did take those down.
Ms. Smith did, it just made his case go away. This guy's name was like Roxon, a lawyer. Did he find you
Yes,
about a consent bond?
yes.
Okay. He came here and was looking for you. I said, this is her home away from home. Okay. All right. So you lost the alternates?
No, they're in the jury room at AC.
Oh, not in this in-between
They
space.
started moving tables and stuff, so I just moved to.
Who was moving tables? The jurors were?
No,
The dream.
jury people.
Oh, okay. So there, because that's an empty jury room now. Huh. No. I just want to make sure they weren't lost. Okay. I mean, with him, you never know. So, okay. Are they ready or are they getting organized? Okay. Are you ready?
Yeah.
Okay. Let's get on the record. I don't know that we ever came off the record, but we had sort of paused because we were waiting on the video. So still on the record, Deputy Gordon tells me that the jury has reached a verdict. Anything we need to cover, Ms. Smith, before the jurors come in and we receive that verdict?
No, Your Honor.
Ms. Wood?
No, Judge.
Okay, then let's please bring the jury in.
All jurors are present and accounted for.
Thank you. Everyone can be seated. A few more people come in. Good? Okay. Deputy Gordon tells me you all have reached a verdict. Is that correct? You're the foreperson?
Yes, sir.
All right, if you could stand. Did you and your colleagues reach a verdict?
Yes, sir.
And was it a unanimous verdict?
Yes, sir.
All right, if you would hand the verdict to Deputy Gordon, please. All right, thank you. I'm going to ask you to publish the verdict, which simply means read in the jury's verdict into the record as to count 1 and count 2.
Okay. On count 1, we find the defendant guilty. On count 3, we find the defendant not guilty.
And you signed and dated the verdict form.
Yes, sir.
Okay. Deputy Gordon, if you would get the verdict form to Ms. Smith, and Ms. Smith, if you get it to Ms. Wood, please. Ms. Smith, do you have any objection to the form of the verdict?
I do not, Your Honor.
Ms. Wood?
No, Judge.
Okay. Ms. Smith, anything else before I excuse the jury?
Nothing further, Your Honor.
Ms. Wood?
I'd like to pull the jury.
Okay, I'll actually do the polling, but it's okay. Ladies and gentlemen, what's going to happen now is that I'm going to ask each of you the same 3 questions so that when I call your name and juror number, if you'd stand and answer the questions, we're just confirming that this was in fact a unanimous verdict. So juror 10, Ms. Batson. Was the verdict read here in court, your verdict back in the jury room?
Yes.
And did you freely and voluntarily enter into it?
Yes.
Is it still your verdict?
Yes.
Thank you. Number 11, Ms. Gibson. Was the verdict read in court, your verdict in the jury room? Did you freely and voluntarily enter into it?
Yes.
Does it remain your verdict?
Yes.
Thank you. Number 13, Mr. Commando. There you are. Was the verdict read here in court, your verdict back in the jury room? And is that a verdict you freely and voluntarily entered into? Is it still your verdict? Thank you. Number 17, Ms. Temple. Was the verdict read here in court, your verdict in the jury room? Did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Number 19, Mr. Forte. Was the verdict read here in court, your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into it?
Yes.
Does it remain your verdict?
Yes.
Thank you. Number 20, Ms. Perez. Was the verdict read here in court, your verdict in the jury room? Did you freely and voluntarily enter into it? Does it remain your verdict?
Yes.
Thank you. Number 25, Ms. Farkas. Was the verdict read here in court, your verdict back in the jury room? And is that something you freely and voluntarily entered into?
Yes.
Does it remain your verdict?
Yes.
Thank you. Number 27, Ms. Pruitt. Was the verdict read in court, your verdict in the jury room? Did you freely and voluntarily enter into it?
Yes.
Is it still your verdict?
Yes.
Thank you. Number 28, Ms. Perullo. Was the verdict read here in court, your verdict in the jury room? Did you freely and voluntarily join that verdict? Does it remain your verdict? Thank you. Number 30, Ms. Holland. Was the verdict read in the courtroom, your verdict back in the jury room? Did you freely and voluntarily enter into it? Does it remain your verdict? Thank you. Number 32, Mr. Lostutter. Was the verdict you read here in court your verdict back in the jury room?
Yes.
And did you freely and voluntarily enter into that?
Yes.
Is it still your verdict?
Yes, sir.
Thank you. And finally, number 35, Mr. Logan. Was the verdict read here in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that? Is it still your verdict? All right. Ladies and gentlemen, you have completed your service as jurors in the case of the state versus Julian Terry. On behalf of everyone involved and on behalf of the county, thank you for your time. 3 days worth of your time, last Thursday, all day yesterday, and a good chunk of today. We needed your focus and problem-solving abilities to bring closure in this case. The state brought its allegations, and Mr. Terry maintained his claim of innocence. You heard the evidence, and you reached the verdict that you did. Thank you for your time and attention to this matter. I'm going to ask Deputy Gordon to return you to the jury room. We will reunite you with your devices. We're going to get the alternates back there. I'm going to come back and offer a few more words of thanks and answer a few questions that you may have. And you'll get letters that indicate you've been here, you were here Thursday and all day yesterday and today. It's good through today. You're welcome to go to work after this, but the letter covers all of today as well. So I will see you in just a moment back in the jury room.
Sure.
Ms. Smith, any reason we cannot do sentencing this afternoon?
No, Your Honor, we just asked for maybe 30 minutes before.
I'll give you at least 30 minutes. We'll do it this afternoon, though. Ms. Wood, any reason we cannot do sentencing this afternoon?
No, Judge, I do just need to speak to Mr. Terry.
Okay, you should. Why don't we reconvene is 2 o'clock too soon, or does 2 o'clock work for the state? We'll reconvene at 2 o'clock for sentencing in the matter of State versus Terry.
Thank you, Judge.
Is you ready? We are back on the record in State versus Terry. Mr. Terry is in court with his lawyers. We've got Ms. Smith, Ms. Bush here from the state, and we need to talk about sentencing now. The jury found Mr. Terry guilty of count 1, not guilty on count 3. So I'll start with you, Ms. Smith, if you want to let me know what you believe the sentencing range is, and then what your recommendation is, and anything else you want to present.
Yes, Your Honor, thank you. The minimum in this case is 15 years to serve. It's a mandatory minimum, and the max is 30 years to serve. In this case, the state will be asking or recommending that the sentence be 25 years to serve 20 with the balance probated. And we believe this for a couple of reasons. First, I want to start with, there was a pretrial offer of 15 years to serve that was declined by the defendant when he decided to go to trial. And just a little bit about the defendant, he has a 2024 Fulton County ag assault case, full disclosure, that plea in that case happened after the events in this case, so post-dates it.
Okay, so he has a conviction for aggravated assault here in Fulton. It's a 24 indictment, and whenever the plea was, it was post August 24th or 28th.
It was indicted before 2024. He took a plea in 2024, I'm sorry.
Okay.
Yep.
But the plea was after the incident that this case is about.
That's correct.
Okay.
Moving forward, the concerns that the state has, and particularly that's what's troubling for us, and the reason why we're asking for 25 years to serve 20 is just for the reasons of the evidence that came out during the trial, the fact that Mr. Terry possessed over 200 grams of methamphetamine. That is a large amount, a large quantity that we're dealing with here. And I think the bigger issue is that 1, it's illegal, and 2, that these drugs were intended to be distributed to the community. So the people in the community, and because of the characteristics, how the pills look, the faces on it, the hearts, the multicolored, this could have been picked up by a child. This could have been picked up by anybody. And I think the concern for the state is that it could have gotten in the hands of anybody, and it could have been, we could have been talking about something else different today. I think the most troubling thing for the state is that this was the incident that Mr. Terry was caught for, or arrested for. However, we know of 2 previous successful drug deals that happened where Mr. Terry sent 2 other people to those locations on his behalf. But this operation was so notorious and big in a way that the FBI partnered with the South Fulton Police Department to even open this investigation into Mr. Terry because of the dealings that he was doing in South Fulton. We believe that because of those previous incidents with Ms. Lynch and Mr. Adams, in those cases, there were still large quantities of methamphetamine that was being sold. At no point was this for personal use, even though that's not okay either. But we're dealing with something where it's a large quantity of illegal drugs that is being distributed out into the community. Drugs are dangerous. Putting them in the community is not safe. And because of that, the state is asking for 25 years to serve with the balance probated.
I thought you said 25 serve 20.
What did I just say?
You may have said something different, but I want to make sure I'm clear.
Sure.
Your recommendation is 20 to serve, followed by 5 years on probation.
That's correct.
Got it. Okay.
My apologies if I said something different, but that's all from the state, Your Honor.
Okay, thank you so much. Ms. Wood, because this sentencing is not a scheduled event, we don't have pretrial here. Do you have any different information about criminal history?
Sure.
Okay, I'd like to hear what you have to say about sentence. Oh, Ms. Smith, it's not quite done.
Apologies,
It's okay.
I forgot to include the fine in this case of $300,000. So in addition to the 25 years to serve, 20 would bounce probated, the state would be recommending the $300,000 fine in this case.
That's a big number.
It is.
Is it a mandatory fine?
It is.
Okay. I knew there was a big number associated with trafficking. Okay. Ms. Wood.
Thank you, Judge. Your Honor, Mr. Terry is 45 years old. He's originally from New Jersey. He's been here in Georgia since 2010. He has two daughters, ages 8 and 18. His 18-year-old is in college. He was working in construction before he was injured in 2015. He was in a wheelchair from 2015 up until 2019. It's my understanding he was actually shot and injured while trying to be a good Samaritan. So no good deed goes unpunished.
That's a different injury from the construction injury, or he happened to be working in construction when he was shot?
I'm sorry, I don't think he was working when he was shot. I think he was intervening. He saw domestic violence happening and he intervened and was shot and injured.
Got it.
He has family present. His mother's here. His fiance is here. Your Honor, I also have a letter from his pastor, Pastor Clarence Hampton from First Baptist Church of Stewardship. If the judge of the state wants to read it, he just basically writes a paper or a page about how he's worked with Mr. Terry for many years and he's known the family a long time. And I can attest, I actually called Mr. Terry this past Sunday to talk about trial prep, and I heard praising going on in the background and he had to step out from church to talk to me about this case. So, Your Honor, I'm asking the court to sentence him to the minimum of 15 years. I don't believe he should be punished beyond that. Since that was the state's offer, he shouldn't be punished for exercising his right to go to trial. And I will let the court know I've already begun the motion for new trial process for him.
Okay.
And I don't know if anyone wants to speak for him, but I know you usually let people talk. I didn't know.
Sure, and I'll inquire in just a second. So no probation, just 15 years straight is your recommendation? Okay, got it. So Mr. Terry, I'll come to you in a minute. Ms. Wood, do you want to see if anyone besides Mr. Terry wants to speak? Okay.
His mom would like to speak to it.
Okay, ma'am, if you would come, where you, up to the podium. If you come up to the podium, please. That way, Ms. Rivers will be able to hear you.
Good afternoon, everyone. My name is Clarette Terry. I am the mother of Julian Terry. Excuse me.
It's okay, take your time. And we're gonna get a box of Kleenex to you.
I know Julian hasn't been a quiet boy. I know he's made some mistakes. But since the past 2 years, he's been trying to change his life. And as he said, his situation began back in 2015 when he was in New Jersey and he was shot 13 times. And he's here by the grace of God. He has issues, yes. He has substance abuse issues that's never been brought up. First of all, he's finally coming to the realization that he has a problem. He's been going to rehab. He's been doing the work. And as a family, we try to encourage and empower one another. We also chastise and we correct each other. This situation unfortunately happened at a time when Julian was at his lowest point in life. Wasn't thinking clearly. He wasn't acting correctly. Trying to make him realize you have to do the work to get the help that I can't do it for you. But finally, he's had an epiphany in the past year and a half when my granddaughter, his daughter Jay, she's going to college in Delaware University.
In Delaware, you said?
Delaware
Great.
University. And his youngest daughter, Mahari, who's 7, they love him. They think he's the greatest thing on this earth. And I think by they're growing and getting older, he's realized the errors of his ways and he's been doing better in terms of trying to correct the errors of his ways. Again, he's not a Boy Scout, but I believe God is a God of a second chance, and not just a God of a second chance, but God of another chance. He's been going to church. He's been encouraging the men in the church, help with the church. But all I know is that I just ask if some kind of grace and mercy can come through this. And I'm 66 now. I have medical issues. I love all my children the same. I raised them all the same. And always is one. You know, when they're young, they're around your ankles, but when they get older, they're around your heart. But all I can say is this too shall pass. But I just wanted to let you know that I think you did a good job. You did your best. And I thank you for whatever, but we're gonna still try to fight and do whatever we can to see him try to eventually move forward out of the situation by the grace of God. That's all I have to say, and thank you.
Thank you for being here. And Mr. Terry is fortunate to have family support and to have had your nurturing for the many years that he did. Mr. Terry, you also have the right to be heard if there's anything you want to say. Oh, I didn't mean to cut you off, ma'am. If you want to come on up to the podium. The fiance.
Hi, everybody. I would just like to say thank you.
Can you give us your name first, just so we get it in the record?
I'm Jamie Denise Tyler.
All right, Ms. Tyler, thank you for being here.
Thank you for having me. I just want to say thank you to you guys for your hard work and trying to, help Julian. I just want to piggyback off what his mom said. Julian has been doing the work to become just a better person with family, with his children, even in the community. He has been going to therapy. He's actually scheduled, we didn't know what the outcome of this would be, but he's actually scheduled to go into rehab in person, in rehab system. And so I think, Axon, he took it to trial because the DA before him had offered him 5. And that was too much for him because he has things that he has aligned for in the future, things that he wants to do with his children. We're supposed to be moving to Panama in 2 years.
Panama?
Yes, to just, start all over, just start brand new from scratch.
Why Panama?
Just because I need to be a little closer because my mom is sick. She suffered from a stroke. And I need to be able to get back to her in time if I need to get back to her. But the ultimate goal is violent. Like we just want to start a brand new life somewhere else and just live different from dealing with the stress of just the United States alone. Just living here is just very stressful. And of course, with all the things that he has been through with being shot so many times, being paralyzed, getting back to where he is now. As his mom said, he made mistakes. We all made mistakes. 15 years is a lot of time. And had he known it would have went up to 15 years, I'm pretty sure he would have took the 5 years that was offered prior to, the new. So I'm just asking that, just look at, everybody that's going to be kind of doing a time with him. He has his 2 children.
Right.
He has his mom, of course. And of course, he has me and my mom. Yeah. So it's going to be a heavy, heavy burden for all of us. And I don't think he's deserved it because of how he has been trying. I mean, consistently trying, doing the work on his own. Of course, with a little guidance from mom, but he's been doing the work. So his past shouldn't affect his future or everybody else's. And then plus, the DA really didn't have a good case and there was a lot of inconsistencies. And he thought he was buying ecstasy. They never changed the word to ecstasy. They kept the word meth. 2 different things. And I get trafficking is trafficking. I know they have a job to do, but at the same time, you're trying to damage a Black man's life when he's trying to do the right thing. And you're not being fair with the wording that you use. So, I just ask for a little bit of grace in the decision because it doesn't only affect him. It affects us all. And that's it.
Okay.
Thank you.
Thank you. I appreciate you being here. Mr. Terry, I was going to say. If there are things you want to share, you are free to do that. You don't have to say anything at all. Your lawyer has spoken on your behalf. Your mother has helped me understand that there's much more to you than the parts that we saw in the course of this trial. And your fiance has also helped paint a more complete picture of who you are and what you've been through. But if there are things you want to add, this is the time to do it.
Yeah, I do. Main thing I want to say, the main thing, I'm not a drug dealer. I might have been a lot of things in my life, but I'm not a drug dealer. Never been a drug dealer. I tried to work. I was good with my hands. Got shot up. I laid off from a couple places. I had a car. I got shot in my hand out here. I got arthritis. Anything able, like as far as like some big time drug dealing and all that, I wouldn't be here with a public defender. I wouldn't be out on the bail program or whatever. Like I didn't even pay to come out on bail. I'm not saying I'm some type of good guy, but I got principles. There's a reason why when they even ask me as far as like I got a deal, I got asked if I wanted to rap or tell or whatever. I live by a certain code, certain principles. I was raised, got a father, you know. So there's certain things like I can accept my fault, but it's certain things that I'm not. That like even sitting here, that's why I was making faces and stuff like. My father died from using ice, which is called meth. I never knew what it was until I found out about it was what it was. Where I'm from, nobody don't do ice or meth or anything like that. I thought what it was ecstasy. I spoke about it with my lawyer and everything else, whatever. I thought I had a good case. I thought I looked as far as like you seen even when I came in that day for jury selection. I was out all night, working all night. I came in here, that's why I came in late. I told you what my situation was. You know, I don't never think I gave a perception of what I was made out to be. Like I was some type of big time drug dealer. I think I was used as a fall guy with my homegirl agent to Adams. You know, I know him for a minute for playing basketball. I'm a straight up and down person. I don't do a bunch of lying. I don't steal. I don't do any of that or whatever. I'm a man at the end of the day. Did I try to do certain things to piss some money in my pocket? Of course, I got responsibility with my kids. I don't like begging people for nothing. I tried to work. I could barely stand on my feet most of the time, whatever. I got bullets in my back. I got a rod in my head. And even at the end of the day, like I'm willing to accept whatever you give me at the end of the day because, you know, I whatever I did, I've done. You know, but I know at the end of the day, I'm not no meth dealer or anything like that. And that's one of the reasons why I took it to trial because at the end of the day, I'm not about to push something that my father died from using. That's why I was affected when I heard people saying it in the jury. But I can't say nothing about it. But I'm not about to plead guilty to that or whatever. I'd rather take whatever I get and plead guilty to something that took my father out of here. I'm not doing that. That's all I really got to say.
Okay. Well, I'm sorry for the loss of your father in those circumstances. That means you probably understand my perspective on this, which is whether you were involved in drug transactions for meth or ecstasy or ice or crack or powder or whatever it was. It's stuff that kills people. It's stuff that these days we don't know what's in the pills. And it doesn't take much for the wrong thing to be in the mix. And people are losing their lives, they're losing their careers, they're losing their families. And so I'm not putting a label on you. I'm reacting to the evidence that I saw, and you and I both know there was a whole lot more evidence that didn't come in, recordings with your voice on it, that I think would have made the case even easier for the state to prosecute. But I hear you that you didn't think that what you were mixed up with on that day was meth. My concern isn't, was it meth or was it something else? It was stuff that you knew messed with people in the way that your father suffered from and the way that you suffered from. You haven't told me what you were addicted to, and you don't need to, but your family has said you struggled with addiction. And so you know how it can ruin a life. And you got involved with the transaction that had the potential to ruin dozens of lives. You may recall how I verbally sparred a little bit with Juror 41, who didn't want anything, unless there's a dead body, no one's getting hurt. And I disagree with that, respectfully. I work with addicts a lot in my profession, and I see how upended their lives are because of their addiction, things they can't control. And people who push more product in their direction are a problem. And so you may be thinking, I put a little more money in my pocket, I can take care of my daughter, I can do this or that. What you're not thinking about when you have that side hustle is all the people it leaves behind. How many other fathers OD leaving their son behind because they thought they were buying this and it was meth instead? There's no street test for that. So they buy the pills that you were moving in that transaction, and the next thing we know, they're not around anymore. And that's on you, and it's on Mr. Adams, and it's on Asia Lynch. It's not okay. These are not victimless crimes because of the wreckage it creates in the lives of all those people who are throwing away their money to get those pills. And that's what you did. And you could say it's just a business transaction, but you know from personal experience what is at the trail end of that distribution. The CI, if he was really going to go sell that stuff, he wasn't going to use it. It was going to go somewhere else. But there's that junkie at the end, and you are extending the addiction of that person. As someone who's in recovery, you in particular, I would think would be attuned to the risk that you create for other people by moving that amount of product. All that being said, my hands are fairly limited and tied in this case because of the mandatory minimum. 15 years is a mountain of time for someone who didn't have a gun or a knife or anything like that. You didn't hurt a little kid, not directly, but Ms. Smith makes an excellent point that these look like candy. And an irresponsible parent who's strung out, who leaves 5 of those pills on a nightstand, runs the risk of the 3-year-old walking up and putting 2 of them in his mouth and kill that kid. And your fingerprints are on the bag that had those 100 pills that went from Adams to you to whomever and out into the marketplace. Those are the risks that people take when they're in that line of work. And I say that not to shame you, and I'm not blaming you. There's more to you than that. I heard your mom and I heard your fiance. There's a lot more to you, and hopefully you will get back to that. But in the meantime, I have to sentence you consistent with the statute that says the mandatory minimum is 15 years. I'm going to sentence you, Mr. Terry, to 20 years to serve 15 with a balance on probation. There's a mandatory $300,000 fine. You should know that there is no debtor's prison in Georgia. You will pay that only as you are able to. They're not going to take food off your table to pay that. But while you are on probation, if you are earning money, and you may not, you may be getting benefits by then, given all the injuries you've sustained. But if you're able to pay it, you'll pay it off as some small fraction of the income that you earn. Obviously, the bigger penalty is that time in custody. You will get credit for the time you were in before you were able to post bond through the bail project or however it was you posted bond. And this is a parolable offense. Given your criminal history, you will be very much eligible for parole. And the main determinant of that parole will be how you handle yourself when you are in the Department of Corrections custody. So that's a reason to spend time there taking classes and staying out of trouble rather than getting involved in some kind of nonsense there that will only serve to limit your eligibility for parole. Your special condition of probation will be to submit to random drug screens so that if for some reason when you get out, you're still working through addiction, we'll be able to tell that. And if ultimately probation recommends drug treatment, which you can also get while you're in custody, that drug treatment would become part of your probation. Ms. Smith, do you have anything you want to add? I meant to add this as well as part of my reasoning for the sentencing. This was one of the more peculiar set of drug transactions that I have experienced as a judge or a prosecutor, in that for whatever reason, Mr. Terry was labeled as the primary target, but every time he needed drugs, he had to go to Mr. Adams to get the drugs. And then Mr. Adams either delivered them himself to a customer, the CI, or delivered them to Mr. Terry, who walked across the parking lot and gave them to the CI. So I'm not quite sure how that investigation worked, but it wasn't lost on me, Mr. Terry, that it's not that you snapped your fingers and a boat came from Colombia and delivered the product, but that you called Mr. or however you communicated with Mr. Adams, and he said, hey, I can get this stuff. And so he had a source and ultimately was your source. That's not how the investigation was structured, but that's how the evidence came out, both in the hearings that I handled and the trial that we had. I think that's another reason why The minimum sentence, which is a very large number, is appropriate in your case, as opposed to the state's recommendation, which I appreciate and understand. But if the mandatory minimum were a lower number, I could see going above that. But 15 years, if for some reason you're required to serve all of it, is a very significant sentence in connection with what you've done and your role in what you were charged with. That's all I have to say. Other than this, Mr. Terry, you have a number of appellate rights. Ms. Wood is already working to protect them, but I do need to cover with you what those appellate rights are. First, you have the right to what we call a direct appeal. That would be an appeal to me first for a motion for new trial, and into the Court of Appeals, where a higher court will review the record that was made here and can decide, did the judge mess up? Did your lawyer do the job she needed to do? Was there something the prosecution did that they shouldn't have, that I allowed in? And that Court of Appeals will review the entire record to decide whether your conviction and sentence should be affirmed or reversed and sent back here for proceedings consistent with whatever they direct. Ms. Wood has 30 days from today to file on your behalf either the motion for new trial, which is a placeholder, or the direct appeal. You get to do both. You could just do the direct appeal, or you could say, I want the motion for new trial. If that's denied, then I want my direct appeal. It sounds like Ms. Wood is already working to get that motion for new trial filed. If you exhaust your direct appeal rights and they are not successful, in other words, if your conviction is affirmed and your sentence is affirmed, you also have the right to what we call a habeas challenge. You do not have right to counsel for that. You'd have to do that yourself, but that clock does not start ticking until you've exhausted all your direct appeal rights. And you will have a lawyer assisting you with your direct appeal all the way through. It won't be Ms. Wood. A lawyer will be appointed to replace her, who can independently look at the record and make an assessment of whether Ms. Wood did everything she could, or if she did something the wrong way. That can be challenged. And as I mentioned, decisions I made can be challenged. Things the state did can be challenged. When that direct appeal is over, like I said, you've got this habeas challenge. You have to bring that on your own, or you have to hire an attorney to do that. That's 4 years after your conviction is affirmed by the highest court that ends up hearing it. So that's a ways down the road. You don't need to worry about habeas yet, but I need to tell you about it because it's a whole nother bite at the apple in terms of appeals if you decide that your direct appeal was wrongly ruled on by the appellate court. I laid a lot on you. I know Ms. Wood will explain more about it, and she's already taking steps to preserve your appellate rights. Any questions about anything I said about your appellate rights?
No.
Okay. Ms. Smith, thank you for your hard work on this case. Ms. Wood, you as well.